All right, so we're going to go ahead and call Senate Commerce and Labor to order. Madam Secretary, please call the roll.
Senator Hardy? Here. Senator Lang? Here. Vice Chair Neal?
Here.
Senator Pickard? Here. Senator Scheibel? Senator Settlemeyer? Here. And Chair Spearman.
Okay, Madam Secretary, please mark Senator Scheibel and Senator Spearman excused. They are presenting bills in other committees. We have a full agenda this morning. As everyone knows, we're hybrid, so we're in between Zoom and being physically present. We're going to go in a different order for the bills today. I'm just going to go ahead and get it started and opened up. But we are going to start with AB 250. And then once we do AB 250, we'll go in the normal order that's on the agenda. So I want to call Assemblywoman Howdegee to the table.
Vice Chair, can I bring Mr. Burford with me?
Yes. I'd be like, no, he can't come. You may proceed.
Okay, thank you. Good morning, Vice Chair and members of Commerce and Labor. It's so nice to be with you again. And excuse me, I forgot it was Jean Day, so I am not wearing jeans today. But thank you for taking the opportunity to schedule and hear Assembly Bill 250. I'm Sandra Howdegee, Assemblywoman for Assembly District 41. And today I will be presenting Assembly Bill 250, which establishes the birthday rule for persons who are currently enrolled in the Medigap plan. What I would like to do, Vice Chair, with your permission, is walk through some brief remarks, then turn it over to my co-presenter, Christopher Carruthers. And I believe, yes, she's right there. We also have Ms. Heidi Sterner with their health underwriters who will be giving remarks after Mr. Carruthers.
Okay, thank you for that.
Okay, thank you. Well, the genesis for Assembly Bill 250 was from one of my constituents, Rick Bronstein. Over coffee, Mr. Bronstein explained that Nevada has never had an open enrollment for Medicare supplement plans. As you know, the Medicare program, which is administered by the Centers for Medicare and Medicaid Services, also known as CMS, is the federal health insurance program under which qualified individuals receive health care. Medicare does not cover all medical services, and it also does not pay 100% of certain covered services. Although Medicare pays for certain preventative services and covers most medically necessary services, the percentage of out-of-pocket healthcare expenses for Medicare beneficiaries can be sizable and typically increases with age. Medicare supplement insurance, also known as a Medigap policy, is a distinct type of insurance which is sold by private companies to fill the gaps in original Medicare plan coverage. Medigap policies are guaranteed issuance at certain times for eligible beneficiaries as specified by state and federal law. For example, at the point where an individual first becomes eligible for Medicare, there is an open enrollment period when Medigap coverage can be purchased without medical underwriting. Medigap policies are guaranteed renewable as long as the premium is paid and, generally speaking, cannot be canceled because of a person's health condition or for any reason other than non-payment of premium. Insurers can, at their discretion, increase the premiums for Medigap coverage. However, unless eligible for open enrollment or guaranteed issuance, Medicare beneficiaries wishing to purchase Medigap coverage or change plans are subject to medical underwriting and can be denied coverage based on their health status or claims experience. What is so great about the birthday rule? It provides an opportunity to enroll in a plan from a company that may offer better coverage to suit the needs of the consumer without medical underwriting. This means that just like when a person first signs up for a supplemental insurance policy during an open enrollment period, an insurance carrier is prohibited from denying coverage based on pre-existing health issues. Assembly Bill 250 requires an insurer, nonprofit hospital, and medical or dental service corporations that issue an insurance policy that provides for the payment of expenses not covered by Medicare to offer an annual enrollment period to change a plan of equal or lesser benefit without being subject to medical underwriting. The open enrollment period would begin the first day of the birthday month of an enrollee and continue for 60 days. This bill also provides that 30 to 60 days before the beginning of the open enrollment period, an insurer must notify enrollees of the dates the open enrollment period begins and ends, any rights of the insured to change to a different plan, and any modifications of the current benefits. Assembly Bill 250 offers Nevadans who have Medigap policies to annually review the price and coverage of their policies. I would like to be clear, though, this measure is not a free pass for people to obtain Medigap policies who do not currently have them. Instead, it allows current enrollees to consider if other policies are available that better suit their needs. Vice Chair, I would now like to turn it over to Christopher Carruthers with Health Underwriters to give some brief remarks, followed by Heidi Sterner.
Thank you for that. Go ahead.
Thank you, Madam Vice Chair, and Assemblywoman Howdeggy for inviting me to be a part of this. So my name is Chris Carruthers. I'm an insurance broker. Been doing this now for 30 plus years in Southern Nevada. My family has also been in it for 50 plus years. We have a family agency. We work with many clients in the health insurance arena, and we have probably over 120 active insurance producers that work through my agency. I'm also president-elect of the State Association of Health Underwriters here in Nevada, which is our professional organization for the industry to represent our clients and our producers in Nevada. AB 250, as we call it, the birthday rule, is an important bill that will help many Nevadans who are insured by Medicare, along with the Medicare supplement plan, also known as a Medigap plan. Currently, anyone who has medical insurance has an open enrollment once a year. Regardless of their health status, they can move, change, switch to another medical plan. This would include Nevada Health Link, Medicaid, small and large employers, Medicare Advantage plans, except those who have a Medicare supplement plan. And everyone has an open enrollment to move to a new plan regardless of health status, except those who have a Medicare supplement plan. This bill allows for those who have Medicare supplement plans to switch to another Medicare supplemental plan once a year around their birth month, to another company, or to a current insurance carrier that they're currently insured with at a new lower cost plan, with no reduction in benefits regardless of health status. As insurance producers, we have had our clients receive rate increases every year on their supplemental plans. Clients contact us to change their plans, yet we cannot help them change to a new lower cost health plan due to medical conditions. That would allow them to qualify for lower cost plans. Our association has been discussing the birthday rule for some time, and we've discussed with the Department of Insurance and carriers, and we've had meetings to discuss the impact of this to our clients regarding passing this bill. And we are in full support of AB 250. Also, we've been working with the Nevada Association of Health Plans. There's an amendment of language change. We worked with Tom Clark on that even yesterday, and we are in full support of that as well. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Carruthers. And Vice Chair, there was an amendment submitted yesterday to the committee manager, which is should be on the list. If not, we can forward it to you as well. But this is a friendly amendment.
Thank you for that. So is it Ms. Thurman?
Sterner, Heidi Sterner.
She is Sturm. She's going to be there just to support, right?
Ms. Sterner, would you like to give remarks?
Yeah, I just wanted to, I have a presentation that we would normally cut over first. Wanted to just mention that there are currently approximately 100,000 Nevadans that are currently enrolled in a Medicare supplement plan. So this would drastically improve their ability to have different options, as Chris had mentioned, and the chair of the assembly had, Commerce and Labor had mentioned that they don't have that option today. And so we are looking for that option, and this bill would achieve that goal.
Thank you for that. All right. So members, any questions? Senator Settlemeyer.
Thank you, Madam Vice Chair. I was just kind of curious, since this has been done in other states, it looks like it has the ability to increase the number of people who have signed up on insurance and what that has resulted in other states that have done this before us.
If I can, Vice Chair, I'd like to turn it over to Ms. Sterner or Mr. Carruthers to help answer that question. And Senator, would you repeat your question?
So from what I'm reading, the birthday rule, because it's called the birthday rule, has been utilized in other states and looks like it has the ability to help the constituents potentially get onto insurance when they have not in the past. And I was curious how often or what the percentage is that we've seen in other states that have done this. I mean, what's the potential gain of getting individuals on insurance? Is it like, 2%, 5, 10? I was just kind of curious if you had any data on this since this has been done elsewhere.
Right. I'll do my best because it's kind of what traditionally happens with Medicare supplement plans. The only time someone can go to it is when they're first initially eligible for a supplement plan. So that's when they first enroll in Medicare A and B. They have a window to where they can go to a supplement without any health questions. Or if they retired and they already had Medicare and then they retire from their employer and they had group medical coverage, they are then able to go to a supplemental plan without any questions. Anyone can buy a supplemental plan today who's on Medicare. They just have to answer a health statement like we would do when we buy life insurance or health insurance in the past before the Affordable Care Act. And so what happens is that we have not seen, so I don't see a trend of people moving this direction. What I would anticipate is that those that already have insurance, and I do have a letter from a client who basically says, Chris, I haven't been able to move because of my pre-existing conditions. And my doctors that I see do not accept Medicare Advantage plans. Those HMO and PPO plans are available. They work directly with Medicare services. And so what this is going to really do is just allow those that have a Medicare supplement that want choice to see other providers. They can actually then move to the plan and still be able to afford it, because what happens as the rates increase, it becomes a financial burden to some of them, and to be able to move to a lower cost plan will allow them the freedom to continue to have the quality of care that they're looking for, seeking. And on a Medicare supplement plan, to elaborate a little bit more, they're not bound by a network of providers. They pretty much have the ability to seek care throughout the United States. That's the advantage of a Medicare, original Medicare with a supplemental plan.
Thank you, Vice Chair, and thank you, Simon. Good bill.
Members, any additional questions? So I had a question on the amendment, the strikeout of innovative benefits. So what are innovative benefits and what are we taking out without limitation?
I can help answer that question if you would want me to. This is Heidi Sterner for the record. Innovative benefits are optional. They're not required. And there's basically with Medicare supplements, there's like a plan G, plan F, there's a core set of benefits. Innovative benefits would allow the insurance company to add additional benefits such as vision, dental, hearing, and they're just an add-on to the core supplemental benefits. That's what, thank you.
So can I ask additional question about that? Does that also include, so you could have dietary supplements, you could also have some coverage of, I won't say it's like, so if somebody has a breathing machine, different things that they need to get covered, is that considered optional? Or is that under the standard Medigap?
Those would be, Heidi Sterner for the record, those would be considered under the core benefits.
Okay.
These are simply add-ons, optional add-ons that aren't typically seen in a Medicare supplement plan.
Okay. And so just to get a further understanding, so you guys deleted it because this would add additional costs? Or you just were trying to work with stakeholders?
So, Madam Vice Chair, why we were willing to remove it is because it allows the freedom. Because some of the plans, so let me take a step back. So the core plans that Medicare have created, the alphabet of plans A through N, they're all standardized. They're all identical. The only thing that separates a carrier is the plans is the name of the carrier and the premiums. Okay, so a plan F is a plan F, a plan G is a plan G, for example. Then what's happened is some carriers have added the innovative benefits, which is gym memberships, dental, vision, hearing, to kind of name a few that's common in Nevada. And we didn't want that to stand in the way. So if someone has a traditional G plan, they could, with the way the language now reads, is they can move to a G with innovative benefits with no consequences. So they don't have to be treated unfairly. They can purchase any plan G, whether it was G or innovative. They can move at open enrollment once a year to whether it has innovative or doesn't have innovative. They can actually have those new added benefits. Some of the innovative plans, believe it or not, are less expensive than the current traditional Medicare supplement plans, which is kind of odd, but the reality is it does. So it allows people to move, flexibility to move back and forth at their birth month, regardless of if it's innovative or not. That was the intent of the language change.
And if I could just add, so what we didn't want to happen and why we changed the language was if someone had a G with innovated, we thought the language was too restrictive, that they would only be able to move to a G with innovative. So.
And so I just have one final question. So in regards to, because you said their health condition doesn't matter if they get in Medigap. So if a person gets in and let's say, because typically families find out, right, they're on Medicare and then they're looking for the additional Medigap and then they're searching for the coverage. So if the person is in a rehab facility, what happens, what is the process if they're denied, this bill passes, they're denied the Medigap coverage, the family seeking to try to get this additional coverage for other things, what's the pathway? Who do they go through? Are they calling Medicare or who are they calling if there's a denial?
Assemblywoman Sandra Howdigi for the record, and I'll jump in. And so this isn't giving additional coverage. The birthday rule is actually only applying to people who already have supplemental insurance policy. So you have to have this insurance to take advantage of the birthday rule. So if when you're eligible for Medicare, you then buy a supplemental insurance plan, which you're eligible for when you first sign up for Medicare without underwriting, then what the birthday rule does is it allows you during your birthday month to switch insurance policies without going through that underwriting. So that's the only time the birthday rule would apply. So if someone already has Medicare and in the future then they want to buy a supplemental policy, but they didn't go purchase it during that time period when they weren't eligible for the exemption of health underwriting, then that's completely separate and apart from this bill. And then I'll just turn to my co-presenters to make sure I stated that accurately. Okay, thank you.
We're in agreement.
So thank you for that, because I was just asking, because I know it's just very interesting bills that have coming through this session, because I had to deal with Medigap this summer, but I was looking for additional coverage for my dad, but he was already had Medigap, right? But there were things that I was seeking, and then so I'm just trying to get an understanding about what would happen when in a situation where somebody is super sick, we need to adjust the plan, right? And then the denial that could happen. And I'm just wondering what the process was, because I had to call like the Medicare office and then say, hey, here's the things that I want. And then I had to put him on the phone to then talk through and adjust different things. And so I'm just wondering, like, I get what it is, but I'm saying if somebody says, yeah, you're switching, but these optional things, I don't think these are good for you or whatever, right? Who do you go to?
Thank you, Madam Vice Chair. Chris Carruthers again for the record. Generally, people go through an insurance professional to help them enroll in a plan. And just to clarify, Medicare has standardized benefits. And so whatever Medicare pays for, the supplemental plan will pick up the balance. So there is no additional benefits you can purchase through a supplemental plan. The innovative is just little extra healthcare options that are kind of just nice little giveaways. There's no really additional coverages you could purchase, like a long-term care cover policy. That's not a part of it at all. So really it's just the supplementals are just to pick up the balance of what Medicare pays for. If Medicare doesn't pay for it, the supplemental can't pay for it either. If Medicare pays, the supplemental picks up the balance. The simplest way to understand it. Hope that helps.
It does. Thanks. All right. So, Senator Pickert.
Thank you, Madam Chair. I think it's also important to note, and just I brought an identical bill. Mr. Bronstein and I were talking back in 19 about this. And one of the things I think that it's important, and I think it may help you understand how, what we're trying to accomplish here is that people, when they're in the system, and then they have some problem, creates a pre-existing condition, that's part of the issue. The other part of the issue is that as people drop out of these plans in Nevada, you can't move from one plan to the next plan. And so as that pool gets sicker and smaller, those premiums are going to go up. But in Nevada, unlike the states around us, we can't move to a less expensive plan. And so what this bill will do is allow people on their birthday or around their birthday to find a less expensive plan. It doesn't actually change the benefits they're getting for the most part, except for the innovative stuff. But it allows them to move to a new, cheaper plan, and it keeps their costs down. Otherwise, in Nevada, they're locked into a plan for the rest of their lives, and that plan is going to increasingly be priced out of reach. Those prices are going to go up because their pool gets smaller and more expensive as time goes on. And this is one of the things that, this is how they make money. I appreciate that. But by the same token, we have a duty to allow our constituents, just like our surrounding states, to get into cheaper plans if we could make it available, because that's up to us. We get to make that decision. So that was my two.
If I could jump in, Mr. Senator Pickard had a great point, Chair and Vice Chair, is that what happens is that as premiums go up, people just aren't locked into an insurance plan with higher premiums. They end up dropping them because they can't afford them. And so this would allow them to not have to drop the insurance plan, just maybe transfer to one that's equal or lesser benefits.
Got it. All right, thank you for that. Senator Lang.
Good morning. So how will people find out about this? And I guess it's on the insurance agencies to go out and talk to people, but it seems like it affects a lot of people in a positive way, and I'm just curious how we can get the word out.
Thank you. This is Assemblywoman Sandra Howdigi for the record, and we actually built that into the bill. So you'll notice that in the bill there is requirements for the insurance companies who have insureds with supplemental plans to send them annual notifications 60 days before their birthday to start sending them notifications.
Thank you for that. So we will go ahead and move to support for AB 250. I don't know if there was anybody in the room signed in for support. If not, we'll go to the phone lines for anyone who had signed in for support for AB 250. BPS?
Thank you, Vice Chair. Good morning. If you would like to testify in support of AB 250, please press *9 now to take your place in the queue. Caller with the last 3 digits of 523. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Vice Chair Neal, members of the committee. My name is Tom Clark. That's T-O-M-C-L-A-R-K. I'm here on behalf of the Nevada Association of Health Plans. As you'll see, we brought forward the amendment working with the bill sponsor, Chair Howdigi. We appreciate her work on this bill. And I want to thank Senator Neal for your questions regarding the amendment, and Ms. Turner and Mr. Carruthers did a great job of explaining why the innovative piece is taken out. It doesn't lessen the legislation at all. It actually makes it so that those equal or lesser plans are still available. So thank you, Madam Vice Chair and members of the committee for your time this morning.
Thank you, caller. If you recently just joined us, we are currently in support of AB 250. If you would like to testify in support, please press *9 now to take your place in the queue. Caller with the last 3 digits of 904. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Hello, good afternoon, good morning, Chair Spearman and members of the committee. My name is Alex Camberos, that's CAMBROS, seeking in support of AB 250. As you know, medical needs vary among many Medicare recipients. Selecting a Medicare supplemental plan can be challenging for a few reasons, and they may later realize that the plan they selected may not be the best choice for them, or perhaps it's become too expensive and they like to review what other options are available to them. Giving consumers an option to choose an equal or lesser plan during a special enrollment period coinciding around their birthday gives them flexibility to choose a plan that can better suit their needs. With over 100,000 Nevadans enrolled in a Medicare supplements plan, AB 250 is essential. I want to thank Assemblyman Howdy for presenting this bill, and I thank the members of the committee for their consideration. Thank you.
Thank you, caller. And again, for those who recently just joined us, we are currently in support of AB 250. If you would like to testify in support of AB 250, please press *9 now to take your place in the queue. Vice Chair, you have no more callers in support at this time.
Thank you for that. We'll move to opposition for AB 250.
If you would like to testify in opposition of AB 250, please press *9 now to take your place in the queue. Vice Chair, you have no callers in opposition at this time.
So move to neutral for AB 250.
If you would like to testify neutral on AB 250, please press *9 now to take your place in the queue. Vice Chair, you have no callers neutral at this time.
Okay, thank you for that. So we will, any closing remarks, or you guys are good? Assemblywoman Howdy? Okay, all right. So we will, Senator Hardy.
Thank you, Madam Vice Chair. As I read it, it's more than a month. It's up to 90 days if your birthday was on the first of a month. When you start looking at that month and 60 days thereafter, or is it 60 days? So it's more than a month.
I'm like, you might want to come back to the table.
Thank you for the question, Senator Hardy. This is Assemblywoman Sandra Howdy for the record. Our language is for 60 days from their birthday. That's what our intention was, to give them 60 days from the day of their birthday, so not like their birthday month. It's 60 days from the day of their birthday to look at a different plan.
Appreciate it. Thank you.
Thank you. And I just want to thank the committee for hearing the bill since I'm here. And I would like to thank my constituent, Rick Bronstein, for bringing it to my attention. I think it's a good change for our state.
All right, thank you for that. So we will go ahead and close the hearing for AB 250, and I will turn over the gavel to Senator Spearman.
Thank you, Vice Chair. And so we will now open a hearing on Assembly Bill 4, and I see Commissioner Richardson. So, Commissioner, begin when you're ready.
Thank you very much. Good morning, Chair Spearman, Vice Chair Neal, and members of the committee. My name is Barbara Richardson, and I'm the Insurance Commissioner for the state of Nevada. I'm here to present the first of the Division's 3 bills, which is Assembly Bill 4. This bill addresses changes to the Nevada Insurance Guarantee Association, and that's contained in NRS Chapter 687A. I'm also going to be joined by Bob Laudermill. I just want to make sure he's made it. There he is. Okay. I want to make sure he was on the phone. He's the executive director of the Nevada Insurance Guarantee Association. And if we were sitting in front of you, just assume that he was right next to me. Bob's here to provide assistance in answering the committee's technical questions if you have any. So the division has also provided for you all an explainer table, and it summarizes both the language and the reasons for the requested changes for each section of the bill. And we've done this for each of the bills that we're presenting. In explaining the request for the bill, I'd like to provide some of the context on why we thought it was important. As most of you know, the Insurance Division's primary focus is the regulation of the Nevada's insurance industry, and that produces approximately $19 billion of annual premiums written on Nevada-based risks. Nevada's insurance premium tax provides the state's 4th largest source of general fund revenue, and it generates over $440 million of taxes collected. And this is just a note for the last fiscal year. Insurance is currently the largest financial sector in the United States and is the only financial sector that's primarily regulated by the states rather than the federal government. And most insurance carriers doing business in Nevada transact insurance in multiple states, and many are national companies. Through the National Association of Insurance Commissioners, or the NAIC, the commissioners work together to create a regulatory framework that provides increased uniformity for insurers, for data sharing, and to support and to help create more efficient markets and better consumer advocacy. This bill is intended to update NRS 687A and is based upon model language that was created by the National Conference of Insurance Legislators, or NCOIL, the National Conference of Insurance Guarantee Funds, and the NAIC. The Nevada Insurance Guarantee Association, or Guarantee Association is what we tend to call it, is a nonprofit association created by the Nevada Legislature to pay certain claims of Nevada insurance consumers in the event of a property casualty's insurer's insolvency. And there's a possible maximum payout of $300,000 per claimant. All insurance companies that are licensed to sell property casualty insurance in Nevada are required to be members of this association and contribute to this fund. Insurance members can offset their insolvency assessments to the Guarantee Association with credits on their premium taxes, and that's at a rate of 20% each year for 5 successive years. So insurance solvencies can ultimately create reduced general fund tax collections. The following is a brief overview of the changes being proposed in AB 4. So sections 1 and 18 remove the references to NRS 687A.110 in relation to the provisions being eliminated in section 15 of this act. Sections 2, 3, and 4 add definitions for the terms persons and self-insurer. Section 5 limits the claims which may be asserted against a person insured by a policy issued by an insolvent insurer. Section 6 adds vendor single interest and collateral protection insurance to the types of insurance that are not covered by the Guarantee Association and describes what is not covered by the association under insurance of warranties and service contracts. Section 7 makes this section consistent with definitions added in sections 3 and 4. Section 8 amends what type of claims are covered by the Guarantee Association, extends the claim filing deadline from 18 months to 25 months, and lowers the net worth threshold for first-party claims, which are claims made by insurers, to $10 million. Section 9 changes the amount of the Guarantee Association's obligation requirements by reducing the obligation for unearned premiums to $10,000 and clarifies that the association is not bound by unfunded settlements or releases that were entered into 12 months prior to liquidation. It also adds additional powers to the Guarantee Association and amends provisions regarding lawsuits involving the Guarantee Association. Section 10 removes outdated reference language, and some existing language is rephrased to provide clarification of what the Guarantee Association's requirements are in providing a plan of operations. Section 11 requires the commissioner to provide the association with a copy of any complaint which seeks an order of liquidation against a member insurer. Section 12 extends the subrogation rights of the Guarantee Association for a cause of action which the insolvent insurer would have had if such sums had been paid by the insolvent insurer. So changes of the Guarantee Association rights of recovering to or on behalf of insured of an insolvent insurer, and that would be to only those insureds whose aggregate net worth is more than 10 million, and also to any person who is an affiliate of the insolvent insurer. And it also adds language to confirm that the Guarantee Association is recognized as a claimant in the liquidation of estate of the insolvent insurer. Section 13 extends the types of payers that cannot assert an action against an insurer and are required to file their barred claims directly with the receiver of the insolvent insurer. Section 14 reinstates the current requirement that claimants first exhaust all other available insurance coverage, including a right to defense, before they assert a claim with the Guarantee Association. Section 15 eliminates provisions that cover notifying the commissioner of any member in a hazardous financial condition or to request that the commissioner order an examination of a member insured believed to be in hazardous financial condition, and allows the board of directors to make recommendations to the commissioner regarding matters generally related to improving or enhancing regulations for solvency. These changes are being requested because the association does not investigate nor receive the necessary financial information on member insurers to perform these functions. Section 16 expands the immunity of the board of directors, the commissioner, or the representative of the commissioner to include liability for failure to act. Section 17 changes the time frame an action will be stayed to allow the court hearing on an action against an insolvent insurer or insolvent policy, and it gives them more leeway in the time given to the defendant to prepare a proper defense, and amends the language regarding access to insolvent insurers' records to ensure that the association has access to the insolvent insurer records to be able to act in their stead. This concludes my introduction of AB4, and I stand available for any questions you may have.
Thank you, Commissioner. Do you have anyone else that's going to present with you?
So Bob Laudermill is here to answer questions, but he's not doing any separate presentation.
Okay. Committee members, any questions? No. Vice Chair Neal?
Thank you. So I had a question on Section 9. I wanted to know the circumstances where, because I guess what struck me was in Section 9, because Section 9 is pretty long. So Section 9, if you go to lines 40 through 42, where it says amenable to personal jurisdiction of the courts, I'm trying to figure out, because amenable means like if you want to be. So what's the intent of that language and the use of that word amenable in line 42? And then I have a different question.
Okay, thank you. I appreciate the opportunity to speak and hopefully address any questions or concerns. That insertion phrase there is just basically intended so that we can't be litigations or sued in the domiciled state of the insolvent insurer. The intent is to limit any potential litigation and jurisdiction of any civil matters involving the act to Nevada courts. And there's some other language that also addresses that further on in the statute, that we have a right to address any matters involving civil cases. We want to keep them in Nevada for purposes of interpreting the statute.
Thank you for that. And then I had a second question in Section 9, which this is the part where you guys are discussing the payment in excess for a claim that arises out of. And so I was curious about the section where if the association determines that there may be more than one claimant and may establish a plan, so that's permissive, right? And then it also says in its discretion deems equitable. So I really wanted to get an understanding of how that works, right? Because typically the way I read it, right, you have a claim that arises out of the policy. You could have multiple claimants, and these are individuals that could fall outside of the settlement or the judgment. And so what are the scenarios in which this actually takes place? And then how would that discretion be used to determine what's equitable, because now you're operating outside of the court?
Sure. Well, the intent of this paragraph is really relates to the availability of funds. It's not intended to operate on a specific individual claim. In fact, there's already a provision that relates to the same concept. This is just more of an expansion of the same concept. If you look in the next section further down, I'll just read it. This is already in the existing statute. The association may pay claims in any order, including the order in which the claims are received, or in groups or categories. So this provision is really just an expansion of that concept, and it's intended in case there are funding issues and at the onset of insolvency, it gives the association some leeway in determining which claims may be more appropriate. And from a practical standpoint, there could be workers' compensation claims as opposed to general liability claims, which are have different timeframes for requirements of payment. So this is intended more to address if there would be some sort of complication or availability of proceeding with the ongoing, addressing the ongoing obligations. So, but it's really just an expansion of a concept that's already contained in the existing statute.
Okay, thank you for that. Madam Chair, I just have questions on two more sections. So in section 13, you guys, this is the portion where the claim
Give
asserted.
us the page and line number.
Oh, so section 13, in the paper copy of the bill, it's page 16. And I'm looking at the insertion of the HMO and the hospital plan corp. Because this is where a claim is asserted against a person by the insured. And so I wanted to get an understanding about, because this is new language, can you talk about just a little bit more? I know there was a high-level overview, but just a little bit more about the insertion of the HMO in that provision in section 13.
Sure. Section 5, 8,
Need your
and
name,
13
sir.
kind
Your
of.
name?
Oh, Bob Watermilk, Executive Director, Nevada Insurance Guarantee Association. Sorry. It's best to look at sections 5, 8, and 13 in the same context because they operate in a similar fashion. And I can tell you what the best way to explain it is probably what's in the existing statute already, and then you can understand what this is intended to change. In the current statute, there are certain entities, insurer-related entities that are cannot meet the definition of a covered claim, so their claims are excluded. And in section 8, and then in section 13, these entities are not permitted to file claims against the policyholders, the insureds. Instead, they have to reposition the claim and situate it. It's diverted into the estate. And the idea is that these are sophisticated business entities dealing with insurance. They can withstand the effects of the liquidation, and they can tolerate the estate process, the proof of claim process, and the potential eventual distribution of an amount from the estate. So section 5, 8, and 13 basically are adding in 3 new types of entities, which are considered similar to insurers. They act like insurers, and so they would operate the same way as in the existing statute as other insurers. Their claims against insureds would not be covered within the from the funds of the association, but their claims would have to be diverted and situated in the estate. I would add that section 5 only limits the recovery, and this only pertains to third-party liability claims. It only limits the recovery, the protection, to the amount of the policy limit that was available to the insured. It would not prevent claims. The new statute kind of clarifies that it does not prohibit claims outside of that the prior insolvent policy. So the claims would not be excluded and would not have to be positioned in the estate if the claims are greater than the protection that had been provided under the insolvent policy. And a way to look at the Guarantee Association, we're an early payment mechanism. Insolvencies can be confusing, and it's basically a bankruptcy of the insurer. And the process, there's insufficient funds, is primarily the reason of the insolvency. And the liquidation process can be years before it's resolved, 10, 20 years. So the Guarantee Association operates almost like an early payment mechanism. We provide benefit to insureds and claimants, and then we receive an assignment of the claim and then position the claim in the estate. We can withstand the effects, the long-term effects of the insolvency. So the concept is these certain types of entities can also do the same.
Okay, thank you for that. And then a question on section 14. I see the strikeout, but what drew me to ask a question on section 14 is in line 33. You guys included that they must exhaust all defenses under the policy as well. And so I was super curious about that one because in the original language, was the right under the policy, but you guys went further to be very explicit about when a claim arises from the same facts, injury, or loss that gave rise to a covered claim, and then you want them to exhaust their right to the defense under the policy. And I really wanted to get an understanding about the insertion of that particular piece of the language, because it's kind of like you're basically saying you're saying a lot with that phrasing. So I wanted you to give me an example of, or explain it, and then give me an example of what this actually would apply to when you limit the defense and say that you must exhaust all those remedies within this context.
Sure. The exhaustion provision, the best way to understand that is it's an attempt to avoid any non-duplication of damages. And so under an insurance policy, the two primary rights are the right to a defense and the right to be indemnified. So the insertion of that is really just intended to ensure that an insured has fully exhausted a particular type of right under another insurer policy. The intent of the exhaustion provision is to avoid non-duplication of the damages. There's no uncovered amounts or amounts that would not be, if it's not covered by another insurer, then the association as a payer of last resort would step in and assume the obligation. So in a scenario where it could apply is in a like a complex litigation with continuing losses spread out over many years. A party, an insured, may have 20 insurance policies that could be applicable to the loss, and various ones of those would be providing or have an obligation to provide a defense. And so we would, and we currently operate in this manner. So this is not a new, this would not create any sort of new claims handling, but we would want that insured to fully exhaust the right under those other policies, and that right includes the right to a defense. If the insured is already receiving a defense, meaning its legal bills are being paid by another insurer, again, there's no lapse of any coverage or loss amount. So there would be no amount owed under our statute. So they're already receiving the benefit of, in that example, the payment of legal fees by another insurer. So, but if they exhausted recovery or payment of the legal fees from those other insurers, then the association as a payer of last resort would be there to address the issue.
Madam Chair, just one final question, because I forgot. I did have a question on Section 16. So when I was reading this last night, in Section 16, you guys inserted the no liability or no cause of action for any failure to act. And I guess, immediately what I thought about was, in tort, right? You could have omission, you could have a failure to act, but you have a duty. And there still may be liability that attaches to you, even because you failed to act. So I really wanted to understand the insertion of that, because that is a liability, and it says no cause of action and of any nature shall arise against any member insurer association or its agents or employees, right? And so there's a couple of contexts. There's tort context, there's the business context, where you either omit, you have a duty under some business rule, and now you're pretty much, there's no liability if you fail to act. But in a normal situation, that could inure liability to you. So I wanted to understand that.
Yeah, sure. And you mentioned, I think, the key word, and how I understand the
Give us
purpose
your
of
name,
putting that in
your
there.
name.
Bob Laudermilk, Executive Director, Nevada Insurance Guarantee Association. And how I would understand that or explain the purpose of it. Again, the statute already has an immunity, a pretty broad immunity for any reasonable action taken. And in the context of errors and omissions, professional coverage, the statute already addresses the error side of it. Adding in a failure to act is basically, including the omission side, like as you mentioned. So it's taking into account both potential sides of professional liability, the error side, which is already an existing immunity, and it's also trying to account for the potential omission side of it.
And I guess, and thank you for that answer. I was just trying to understand, like, why do you need it? Because typically, like, if I'm looking for something, I'm looking for your failure to act to come after you. I mean, I'm just gonna put it plain, right?
No,
I mean,
right,
that's
right. But yeah, well, the statute has a built-in immunity provision. It's already existing. So this is really just a further clarification of, I think, just the general insurance concept of errors and omissions. But the statute already has, even if there was a failure to act and there was some sort of institution of some sort of lawsuit against us, we would still assert the immunity statute as is, saying that the reasonable action, we did take all necessary reasonable action. So the failure to act is just a component of the liability of it.
okay. Thank you, Madam Chair.
Thank you. Additional questions? Okay, seeing no additional questions, let's go to those who are in support. Anyone here in the room? So broadcast, let's go to the phones. Support?
Thank you,
Let's
Chair.
do
If you would
15
like to-
minutes, 2 minutes each.
If you would like to testify in support of AB 4, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of AB 4, please press star 9 now to take your place in the queue. Chair, you have no callers in support at this time.
Let's go to opposition, same time frame.
If you would like to testify in opposition of AB 4, please press star 9 now to take your place in the queue. Chair, you have no callers at this time.
Anyone neutral?
If you would like to testify neutral on AB 4, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. Commissioner, you have any closing statements?
It's Barb Richardson for the record. I just want to thank the committee for allowing us to bring this forward and to add these consumer protections for the Guarantee Association and for those who might find themselves at the other end of an insolvent insurer situation. So thank you again.
Thank you, ma'am. And with that, we will close the hearing on Assembly Bill 4 and open hearing on Assembly Bill 18. It revises provisions relating to contracts of insurance and casualty insurance. In case you haven't noticed, today is Insurance Day.
Thank you, Chairman Spearman and Vice Chair Neal and members of the committee. And for the record, my name is Barbara Richardson. I'm the Commissioner of Insurance for the state of Nevada. And I do want to thank you again for allowing me to present the division's second bill, which is Assembly Bill 18. This bill in particular is a focus bill that focuses on two areas. The first is to provide Nevada's automobile insurance consumers additional choices regarding their limits of uninsured and underinsured motorist coverage. And the second is to help ensure that Nevada's renewal with altered term statutory language cannot limit potential policy improvements for insurance consumers. The following is a brief overview of the changes being proposed by this bill, and then I'll be happy to answer any questions you have. So Section 1 was deleted by amendment. Section 2 changed the language related to when an insurer must give at least 30 days notice to an insurer prior to renewing a policy on different terms, including different rates, to include a list of exceptions to this notice requirement where those changes at renewal are clearly consumer friendly. The proposed changes also replace different terms of rates with change in policy or coverage to be less ambiguous. The changes to which the 30 days notice for a change in policy or coverage would not apply would consist of a decrease in the amount of total premium charged, a change in the effective expiration dates of the policy if the duration of the renewed policy remains the same, and changes in one or more conditions of the policy that are intended to provide coverage more favorable to the insured. An example of these types of changes would be an automobile insurer choosing to include towing and road service coverage, or a home insurer including identity theft coverage at renewal for no extra cost or premium to the insured. Under the current statutory language, insurers can be prohibited from making those types of policy improvements or providing a rate decrease if they do not provide the consumers a 30-day notice prior to their policy renewals. So Section 3 addresses a different topic. It provides additional options to the Nevada's insurance consumers regarding uninsured and underinsured motorist coverage in a policy of automobile insurance. Under the current Nevada law, insurers are only allowed to offer consumers uninsured and underinsured limits in amounts not less than the state's minimum limits for liability insurance for bodily injury, and not more than the amount of coverage for bodily injury liability purchased by that consumer. Nevada's current minimum limits for bodily insured injury liability coverage is $25,000 per person and $50,000 per occurrence. The language in Section 3 provides consumers the option to offer limits of uninsured and underinsured that exceed the bodily injury liability limits in a policy. For example, policyholders, those insurers that choose to make this option available, this change provides Nevada consumers the ability to tailor their coverage to their actual needs for protection versus the current limitation of uninsured, underinsured, which cannot exceed the limits of their bodily injury liability. So if you're at fault, or if you're at fault in a car accident that happens to injure someone, bodily injury liability coverage pays for the other driver and their passengers' medical expenses, lost wages, legal fees, funeral costs, and pain and suffering that are a result of these injuries. In evaluating personal exposures and adequate limits of bodily injury liability coverage, consumers may want to consider the amount of their assets and net worth that would be exposed if they were legally liable for injuries caused by an accident. Uninsured and underinsured motorist coverage pays for medical bills, lost wages if you cannot work because of the car accident, pain and suffering, compensation, and funeral expenses when you are injured by a vehicle whose driver doesn't carry liability car insurance or doesn't have enough liability insurance to cover the value of your injuries. When insurers consider the amount of the underinsured and uninsured coverage they should carry, consideration might be given to the amount of their available liquid assets. Like, for example, do they carry robust medical insurance to cover their medical bills? Do they have liability insurance to replace their income in the event of an accident? And there's always the possibility that an accident could make them partially or permanently disabled. The answer to these questions may provide a need for the underinsured or uninsured motor coverage, which might be higher than the liability insurance consumers feel that they need. So the proposed change in Sections 3 are designed to provide the consumer with a choice to make the coverage selections that are right for their individual circumstances. So that's the end of my presentation, and I stand for any questions.
Thank you. Questions, committee? Vice Chair Neal?
No, Madam Chair. I mean, originally when I read this bill, I was just like, what are you doing? But I get it. I have a random question that has absolutely nothing to do with this language, so I'm not going to ask you that. So.
Senator Pickett, no?
Thank you, Madam Chair. As I went through this, this isn't my area of expertise. I always had someone else in the office when we were doing PI cases that handled this stuff. It seems to make sense to me to the extent I understand it. But no, I have a couple of questions, I suppose, as to how the insureds will fully understand and be able to absorb this and make personal decisions, but that's really not on the bill. And I say that because so frequently they don't understand what they purchase anyway. And so I'm not sure that we're going to be making it any clearer to them. But I generally supportive of the bill to the extent that it makes sense to me.
Are you saying that the wording is confusing or lack of knowledge on the part of the consumer?
No, the consumers generally, in my experience at least, don't get into the weeds. So many of them don't even know what uninsured and underinsured motorist coverage is, let alone that they have it. And so, but I don't have any problem with the language of the bill.
Anyone else? So I guess I do a follow-up on what Senator Pickard asked. and I think Penny with a broad spectrum is correct. And this is something I've always wanted to ask, so please indulge me. Is there any way to make the language more ordinary person friendly? Because I think what usually happens a lot of times is people get hung up, the weeds are the third legal tongue that most people don't speak in. And so once you get past that fifth word that's 16 letters long, it's like, okay, I can't do this. So is there any way to make that a little bit more palatable for the average consumer?
So this is Barbara Richardson for the record, and I would love to say that, yes, it'd be really easy to do that. However, the insurance carriers are constantly being sued. So there's a concern on their part of trying to make sure that policies, when drafted, have the legal protections and the legal framework so that there's not confusion when they actually have to step into a courtroom. I know that's not a great answer. We have at the national level been really looking at trying to make policy language clearer for consumers and to try to take as many steps as we can to try to use plain language, especially in the policies, because I agree it's quite arduous, and we're making strides, but it's not always as easy as one would hope to try to turn a contract into plain English.
I think you said intentional, so okay, we'll go with that. No other questions, Senator Pickard?
Madam Chair, if I could just add to that, I want to say about 10 or 15 years ago, there was a big push at the national level to simplify the language. And as the administrator has just mentioned, that it's really driven by litigation and the need for very specific terms so that everybody's clear about how it goes. So while these policies used to be thick with really arcane legalese, they have been simplified substantially over the years, but we can't get away from litigators who will slice and dice every single word with the intention of getting a dollar out of it. So they're kind of stuck. But to their credit, they've come a long way in the last 10 or so years.
Thank you. Any additional questions? All righty. So anyone in the room? No? Okay. So broadcast, let's go to the phones. Those who are in support, 15 minutes, 2 minutes each. Assembly Bill 18.
Thank you, Chair. If you would like to testify in support of AB 18, please press star 9 now to take your place in the queue. Chair, you have no callers in support at this time.
Let's go to opposition, same time frame.
If you would like to testify in opposition of AB 18, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Neutral.
If you would like to testify neutral on AB 18, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Thank you. I can only conclude that maybe our conversation has been as confusing as the documents the consumers read. Either that or they just have no interest in insurance. But I do. I think it's important. Just a little joke. Commissioner, you have anything to say? Any closing remarks?
This is Barbara Richards for the record. No, but thank you all for letting me present the bill today.
Okay, so now we will go to, we'll close the hearing on Assembly Bill 18, and we'll open a hearing on Assembly Bill 45. And who are the presenters?
Thank you, Senator Spearman, Vice Chair Neal, and members of the committee. Please allow me to present the last division of insurance, 3 bills for legislative session. This is Barbara Richardson, the insurance commissioner for the record, and I'm presenting Assembly Bill 45. As most of you who've been around for any time, you'll recognize this as our larger omnibus bill. So it covers a great deal of time and space throughout the entire set of chapters that we have under Title 57. And I will try to be slow. I tend to chat fast, so but to make sure that each section is treated separately, because you'll see that there's not a lot of coordination in this type of bill. It really is trying to hit a lot of different subjects. So Title 57 of the Nevada Revised Statutes happens to contain 59 chapters governing insurance. And we have provided the committee with a table that provides the NRS Title 57 chapter numbers, along with their applicable titles, as it may come in handy in understanding the bill's language. We've also provided an AB explanation table, which contains a section-by-section summary of the language in the changes being proposed, along with a reason for each of the changes we are seeking. And if there's no questions, I'll proceed with the bill presentation. Okay, seeing none. Sections 1 through 2, 6, 46 through 53, 76 through 77, 80 through 85 were deleted by amendment. Section 3 is intended to consolidate licensing bond requirements under NRS 679B so that all Title 57 licenses that are already required by statute to carry a surety bond in favor of the state of Nevada as a condition of holding their license will have uniform surety bond requirements. Currently, the bond requirements vary by license type, which creates challenges and inefficiencies in regulating these licenses. It also causes sureties to develop several bond forms to meet the various license and language in the statutory requirements in Title 57. So these changes will allow for simplified license maintenance and enforcement moving forward. It will make bond requirements easier to understand for the division's licensees. And I want to emphasize that Section 3 only applies to licensees where the existing statutes require a surety bond as a condition for holding that license. It does not create a new bond requirement. So Section 3.2 allows for the commissioner to set a time frame for when provider form letter denials must be submitted by health carriers to try and consolidate submissions. We had been getting them on a daily basis, but then when we actually ran reports, we were running them on a quarterly basis. So we're trying to make it easier for the carriers to submit them on a quarterly basis in a report form so they don't have to send us notifications every day because it was not providing any benefit for either the carriers or the consumers. Section 3.5 through Section 4 and Sections 13.5 and 20.5 create a uniformity for service of process in Title 57 and eliminates the requirement that the serving party physically leave 2 copies of the serving papers. They also clarify that service may be made by actually leaving the notice with the division, and it provides further clarification on the process that the division must take once the service has been made. These new processes are to encourage the use of electronic means whenever practical. Sections 5, 14, 51, 56, 72, and 73 remove the fee language from the various licensing chapters and add references to NRS 680B to consolidate all licensing fees under fees and taxes under the fees and taxes chapter. This allows for greater ease of reference for the regulators and the licensees. And this change is not adding any new fees, it's just moving them from the individual Title 57 chapters. Section 6.05 through 6.95 codifies the 2019 revisions to the NAIC's Credit for Reinsurance Acts, and these are model acts, and they're number 785, and 786. These changes are necessitated by the federal preemption dates that were included in the bilateral agreement between the United States of America and the European Union on prudential measures regarding insurance and reinsurance. And it's commonly known as the Covered Agreement, and it was signed by the United States, the European Union, and Great Britain. This new model language is required for the NAIC accreditation for all states in 2022. State insurance regulators have historically required non-U.S. reinsurers to hold 100% collateral within the United States for the risk that they assume from U.S. insurers. So the Credit for Reinsurance Act primarily concerns the elimination of additional collateral requirements for reinsurers domiciled in the European Union and the UK, provided certain regulatory criteria are met. It also provides for a qualified jurisdiction allowance to obtain similar treatment. For reinsurers domiciled in qualified jurisdictions to obtain a similar treatment as those jurisdictions subject to the Covered Agreement, those foreign countries must provide the same treatment and recognition afforded by the EU countries to the United States based reinsurers as they would receive under the Covered Agreement. The language includes the requirement that a qualified jurisdiction must agree to recognize the state's approach to group supervision, including group capital. So this is a long one. So sections 7, 10, 17, 21, 36, 37, 39, 45, 49, 52, 55, 60, 64, 71, 74, 78, and 79 update the bond requirements within the specific licensing chapters to follow the surety bond requirements I noted in Section 3. Section 8 adds a reference to NRS 682A.179, which provides the terms under which a mortgage on real estate qualifies as an equity interest in relation to rated credit instruments. This reference brings the statute up to date with the accreditation standards and the latest model language of the National Association of Insurance Commissioners. So another long list. So sections 9, 13, 15, 16, 19, 20, 38, 40, 41, 70, 73, and 75 update license renewal language so that the expiration occurs on the last day of the month in which the license was issued. So currently renewal provisions vary across the license type, and this change will simplify requirements for the licensees, especially those who hold multiple licenses or are licensed across several jurisdictions. It also allows the division to streamline internal review processes, including issuing notices, imposing late fees, and the handling of expiring licenses. Section 11 removes the requirement to list all members of a managing general agent on its license and adds a requirement to designate instead an individual responsible for the agency's compliance with relevant laws. This change is consistent with similar license types. Section 12 establishes clear renewal requirements for managing general agents. The current licensing provisions for managing general agent does not address license renewals. So if a licensee does not have the ability to reinstate his license, and the renewal payment is late, they lose their license. We were trying to stop that in here and a couple other sections. So Section 12 adds the language that applies to most licenses under Title 57, which allows for reinstatement of a license within 30 days after the renewal date with a penalty of 50% of the renewal fee, and which for this license type would be $92 as a penalty. Section 15 and 54 establish late renewal provisions for insurance consultant and escrow officer licenses, respectively. These sections also update the expiration date of both licenses to the last day of the month. A renewal is considered late when a request for renewal is received within the 30 days following expiration. It is considered a reinstatement when requested between 30 and 365 days after expiration. This section also clarifies that an escrow officer license expires if not renewed within 30 days of the renewal date. These changes in the applicable penalties are consistent with similar Title 57 license types. Section 18 removes language regarding the automatic refund of license fees upon a denial of a license for motor vehicle damage appraiser, and that's consistent with all other license types in Title 57. I would note that the division's fee statutes do provide for the return of erroneously collected fees under NRS 680B.120. So there is an allowance if the division actually collects fees in error to provide them as a refund. So Section 22 through 35 provides rules for stop-loss insurance, which provides excess loss coverage for self-funded health plans. Section 35 relates to a type of stop-loss policy for health care providers who insure against loss of income through their network contracts with payers. Currently, Nevada statutes do not explicitly allow for stop-loss insurance coverage, and the related rules are instead contained within Nevada Administrative Code. So the reason we're bringing this forward is Nevada is starting to see self-funded health plans sold to groups with as low as 2 employees through an arrangement known as level-funded plans. Because these plans can underwrite and exclude employees with pre-existing conditions and are not required to include all the ACA essential health benefits, and they pay greatly reduced insurance premium taxes to the states, they were able to provide a less expensive alternative to Nevada's small employers. However, if the use of this product continues to accelerate, it has the potential to negatively impact the rates of the Nevada's fully insured small group health plans in the near future. So Section 42 through 44 make clear that maternity health benefits are not for the mother as in the term mother, but for the pregnant person, which is another term. The language is needed to make Nevada's statutes consistent with the gestational carrier laws and the Affordable Care Act. Sections 56.1 and 56.55 codifies the NAIC Model Holding Company System Regulatory Act. These sections are intended to provide U.S. solvency regulators with an additional analytical tool for conducting group-wide supervision in light of the new requirements under the covered agreement. These sections provide key financial information on an insurance group that assists regulators in understanding the financial condition of non-insurance entities within those groups, and information that assists in understanding whether or to what degree insurance companies may be supporting the operation of non-insurance entities. Adoption will further aid the U.S. insurers operating in the EU and the UK. Section 57 requires an insurer or insurance group to annually file any amendments to the previous year's corporate governance annual disclosure, or to expressly state that no changes were made. This language is inadvertently omitted when NRS 692C.3504 was adopted in 2017. Section 58 modifies the captive insurer dormancy provisions by clarifying it applies to captive insurers that are not transacting the business of insurance. It clarifies the differing tax and filing requirements apply once the certificate of dormancy is issued and lasts until the certificate expires or is revoked. And it makes clear that upon expiration of the certificate of dormancy, which is they have up to 5 years, they must be in compliance with all the provisions of NRS 694C that are applicable to any company with an active certificate of authority. Section 59 allows captives to use federally chartered credit unions in the same manner as federally chartered banks, and for the division to perform periodic reviews of captive managers' qualifications and to be able to disqualify those that would be considered unsuitable under NAC 679B.039 through the Commissioner's authority in NRS 679B.125. Sections 61 through 63 clarify requirements related to confidentiality of information submitted in connection with a health rate filing, which will help create uniformity through all the health plans and carriers regarding the provisions of the NRS they are subject to. Sections 65 and 66 clarify that risk retention groups are subject to registration and renewal in Nevada and to a potential determination of hazardous financial condition pursuant to NRS 680A.205. Sections 67 through 69 make changes to the financial regulation of prepaid limited health service organizations, and the provisions make these prepaid limited health service organizations subject to the defined limit of investment and financial examination provisions otherwise applicable to Nevada domiciled life and health insurers. It also clarifies requirements related to the confidentiality of information submitted in connection with a health rate filing and the applicability of the requirements related to the review of health rate filings to apply as attended and in conformance with the division's current procedures. So Section 86 provides for the repeal of NRS 692A.1043 and NRS 695F.180. These sections are no longer needed since the requirements for bonding and investment respectively are being updated as part of this legislation. Section 60 or 87. Wow, Section 87 provides the effective dates of the sections within this bill. So this concludes my introduction of AB 45. I would say that I do understand that there was an amendment submitted last night, and the division has begun its review of the language of the amendment and does have some grave concerns. The amendment as proposed appears to remove solvency protections. This is concerning to the division because the self-insured group market, which the amendment concerns, only has 8 groups in it. So it's a very small, non-competitive market. There are very high confidentiality provisions and protections in the statutes that do not allow the division to provide much information except to say that not all of the market members are financially stable. Removing the protections in the statute would potentially lead to their insolvency, and given the other market players are required to step in to support any insolvent group, this financial fragility could take down the entire market. There is language currently in the statute that allows the self-insured group to work with the division confidentially to help bring them back into a solvent position. And then the other concern for that particular amendment that we noted was that the removal of the audit section is directly against the state's general position that there are concerns of employee misclassification. And the reason I note this is this was just most recently discussed on page A8 of the April 21st, 2021 Northern Nevada Business Weekly newspaper. And yes, I still read newspapers, so I stand available for any questions you may have.
Senator Pickett.
Thank you, Madam Chair. Don't want to disappoint you this morning, and I'll ask some questions. Right out of the gates, one of the first things that I noticed as I reviewed the bill was that, and this kind of goes to my experience on the Sunset Subcommittee, where one of the things that we're trying to do there is to reduce barriers to entry, approve licensing only when it's really necessary or justified. And I noticed I'm on page 13 of the bill, subsection 38, we're starting to license motor clubs. And so, of course, AAA came to mind. They're an insurance company as well as a motor club. So I can see that they're probably already deeply involved with the Department of Insurance. But why are we licensing motor clubs? Aren't these just organizations that are established to help each other, help the members in their motoring lives, but they're not offering insurance per se, are they?
This is Barbara Richardson for the record. Actually, we've been licensing motor clubs for a while now, and it specifically has to do with the services they provide, which sections of it fall into insurance products. There is a risk transfer, and that turns them into insurance entities of some type. We don't have very many of them in the state. There's not a lot of requirements on them, and they're basically what we were trying to do with the sections that we were talking about is to just put them in the same category as the other licensees so that everything can be smoothly handled via systems, and we don't have to actually sort of call them out as separate entities that we would be reviewing either extraordinarily closely or with any kind of extra scrutiny.
All right, I'm grateful for that. I noticed that they're licensing, it's in blue, so I assume that because this is new language, we're adding a licensing fee that we didn't have before, but maybe it's new to this section, and you can address that. But it's also pretty high. I mean, it's $500 for filing an application, and the only ones as I go through that are higher are for full-on insurance companies. And while there may be a transfer of risk, I don't think it's anywhere near the kinds of risks that we're talking about with the full-on insurance companies. So maybe you can explain, number one, why are we charging so much? And number two, why we think that the types of transfer of risk that you're describing justify licensure and oversight. Not that they don't, I just don't understand why.
It's Barbara Richardson for the record, and I appreciate the question. Senator Pickard, and one of the things that you're correct in saying at the very beginning is that this was just a move from the statute specifically having to do with motor clubs into the fees and taxes section. So we weren't actually changing anything. So those fees were determined when the motor club insurer companies were first put under the Title 57 oversight. And that's not really something that we would normally opine on unless it was so high or so low. And the one thing that we do look at with Motor Club, just like we do look at like premium financing, there's these small type of companies that are actually companies. They're not a person. So a person's license fee is always much lower than a company type. So motor clubs are considered a company type, even though they're not company insurers. So for example, service contract providers, which is a company. So they have they initially had a 1,000, it's now 2,000 for a 2-year license. So they're put in that type of oversight and fee structure.
All right, thank you for that. My last question has to do with the self-insurers, particularly the small insurers that you referenced in your presentation, and where these are typically groups, small groups, put together for the purpose of trying to provide insurance for their employees at a lower cost than what they can get on the open market. They have the resources to do it, but they're looking for ways of saving their employees money. I didn't realize that they could be as small as 2, but of course that makes some sense because we don't limit their minimum size. But my understanding of these, and it's only tangential, but it's that they have put together a plan that meets their specific needs, and so they may forego certain coverage requirement or certain coverages. It's done in a way that meets their needs, and so by adding additional requirements that would be similar to the larger plans, don't we end up pricing them kind of out of their intent, which is to save money on a voluntary basis on their own? Because my understanding is they typically do so in a collaborative method where it's not something that they force upon their employees. And by the same token, their employees can go out on the open market onto the exchange and get a plan if they don't like what their employer's giving. So don't we, by adding these minimum coverage requirements, don't we kind of obviate the intent of these plans?
This is Barbara Richardson for the record, and I appreciate the chance to sort of clarify. So the self-funded plans that we're talking about in this particular section are for the level funded plans. We're not actually adding any requirements to them. All we're doing is pulling them up from a sort of lost spot in the regulations to a full-blown potential product in the statutes. And the reason why we wanted to make sure that they were out there and of note is because there are opportunities for using these type of self-funded plans, but so far they've been flying under the radar. And what we're concerned about is the Federal Department of Labor is starting to also pay attention to them. And the real concern for us is that we want to make sure we're not stepping in to do any alteration or require them to do more than they're doing. We want to make sure that people aren't using them to merely get out from underneath the Affordable Care Act requirements, because what ends up happening is if a larger claim comes along, then they move into the fully funded commercial market. And then the fully funded commercial market turns into a high risk pool. So what we're trying to do is sort of give them some legs to stand on, much like the association health plans, which is still another court proceeding that's happening on the federal level. But that was really our intention, is not to give them more requirements, just to sort of bring them into the light.
All right, thank you for that. I was under the impression that when we brought them up into the full-fledged plan environment, the requirements of the ACA would then apply to them, and they would have to have those minimum coverages. But since that's not the case, I'm satisfied. Thank you, Madam Chair.
Senator Settlemyre?
Thank you, Madam Chair. I appreciate that. My question was also dealing with the self-insured groups. I've worked with conservation districts that have actually utilized the self-insured groups. I see their value. I understand your concern about making sure that they're solvent, but in that respect, I was seeing within the amendment there were kind of two parts of it, the assessment and then the audits. Are you objectional to both parts or just the one? It's kind of a question.
So this is Barbara Richardson for the record, and unfortunately, yeah, we are opposed to both of them, mainly, for example, with the audits. The reason why we're concerned is the audits actually help sort of support to make sure that misclassification isn't happening and that the members themselves are protected. And one of the things that we were seeing is there was a request to have an actuary determine the rates, which I normally would say that's fantastic. And having a qualified actuary would be great. The problem is there are levels of qualified actuaries, and there's qualified actuaries that can do property casualty versus those who can do health, and they are different. And we're talking workers' comp, so that's another additional issue. And the companies might find themselves right back in the space where they don't actually have because it's very expensive to get a qualified actuary in the particular market that you're talking about. And we do have advisory organizations that are under the state, which actually are licensed to actually give information to groups like the self-insured groups. So that was a concern of ours under the audits. And then as far as the first part, it really goes back to the solvency protections. There are, if you, don't probably have time to do this, but if you read the sections closely, there's an ability for the self-insured groups, which are, like I said, mostly workers' comp groups, to work with a division to get amendments or some kind of approval to work within their current system. And we actually have been talking to these guys since late 2020. And our concern is that since we're trying to make sure they understand to read the statutes literally, which includes if you're seeing you've got a problem, please come to us and talk to us, and we will work with you, and that we can give you some kind of support through this. But again, our concern is we can't really come out and say anything because the confidentiality protections are so high.
Thank you for that, and I appreciate the concept. Maybe we can, I don't know, I think there might be some potential. Again, I understand your aspect about wanting to make sure they're solvent, but within the other aspect of the solvent, the assessments that might be able to help some of the constituencies that I represent, I was wondering if you'd be receptive to the idea of working with them to try to figure out that particular section to try to find some resolution. Which I understand the confidentiality means you have to kind of work offline, and I understand that.
Yeah, so this is Barbara Richardson for the record. We would like to work with them, honestly, but we do have to work with them one by one. We work with the boards so that we give them a clear picture of where they're standing right now, and then help them try to figure out a plan going forward.
Okay, thank you.
So this is Barbara Richardson for the record. I just want to say, though, that wouldn't require a change in the statute to do that.
Thank you. Vice Chair?
Thank you, Madam Chair. So I had questions on Section 6. So I read the backup. So I'm going to be all over the place, but I'm going to work backwards. So I get generally why Section 6 is there, but what I was trying to understand is, I guess, under the group capital language, where it says that you're recognizing United States, this is on section, because there's several sections, so this is 6.14. I wanted to understand how the group capital piece works. I wasn't sure if the background document that you put in the record, which was the it was the group capital calculation piece applied to this to try to get an understanding, because I guess the thing that I'm stuck on is the, you know, the domicile of the entities that we're talking about, and how I guess it's being explained that the calculation of the risk has to be at the level of the entire group. But what I'm not clear on is the application of this language, which seems to apply not to just in-state insurers, but also EU or other jurisdictions. And so, and I don't know if I'm correct, but I'm trying to understand it. Can you help me?
Certainly, this is Barbara Richardson for the record. I hope I can. It's as you said, it's actually pretty convoluted. But basically, what was happening pre this covered agreement was that that companies, I mean, very large companies who span across the United States, who also span into the European Union, also span into the Asian market and to the South American market, they were having to hold 100% collateral in each one of these jurisdictions, which means money just sitting there. So what had happened originally with the United States commissioners is they worked with the International Association of Insurance Supervisors and through several of the other national or worldwide groups to try to figure out how to look at, for example, say State Farm or Progressive, who may be everywhere. And as a matter of fact, some of the companies themselves have more money and products outside the United States, but they seem like familiar names to us. So the idea was to have a discussion on sort of trying to figure out what group capital was. And so they developed this process called supervisory colleges, where all the group supervisors, or in our case, group commissioners, would come together to meet with the leadership of the companies who had this worldwide market. And they would come in the domiciliary state or country to have these meetings, and it'd be a 3-day in-depth financial review of everything, every risk, sort of how the different types of companies and affiliate contracts were drafted and written, and how they affected each other. So that's the group capital sort of idea. And then what happened was, in order to really make these agreements be jurisdictional, or to make sure that you could actually require jurisdictionally that, for example, Bermuda, if there was a solvency issue with a portion of the company, that they would turn over any additional capital that they may be holding for a United States entity that might be going down. So in order to have all that happen, the United States, through the Federal Insurance Office, which is under the Department of Treasury, signed this bilateral agreement between the United States and and the European Union. And it just so happened that they also brought in the UK, because there was that the big issue with the UK pulling out of Great Britain. So that they gathered that group together so that was easy to be able to sort of make those deals. And then there's a series of oversight that's also done on what's known as qualified jurisdictions. For example, Bermuda is a qualified jurisdiction, and what they do is, since they can't sign this bilateral agreement, they can agree jurisdictionally to be members of this sort of group. And this is all covered under a multilateral memorandum of understanding that covers each state, and then it also covers the qualified jurisdictions. So the group capital is just a base part of that to try to sort of set the stage so that one state, one country can't say, I want more from you than this one does, and you're only going to protect my consumers, when in fact we're talking about huge conglomerates that should be protecting all of the policyholders under their belt. So I hope that helps.
It did help, because what I was trying to figure out was in section 6.1, which covers several subsections, 6.25, etc. I know that the idea was to do this so that you weren't preempted, right? But what I was trying to figure out was, did you deviate at all, or did you just That's what it looked like. Okay, because I was just like, trying to find out what were the differences that you had, because what I couldn't figure out and what I was super trying to understand is when we talk about, like the standard that exists when you're trying to, in these huge swaths of consumers, which could cross borders. I was trying to get an understanding about the language in, I think, the 6.14 sub B, where there was no requirement for the United States to domicile the assuming insurer to establish or maintain a local presence. And so immediately, right, whenever I see maintain a local presence, I immediately get into the jurisdictional piece of this, and like, how does that work when you adopt this and there's, you have to defend an issue. And I understand that it's a multilateral agreement, because I was reading everything that, you put in the record and then went beyond that. But I guess I was trying to understand, how does it work legally? Like, for your example with Bermuda, right? They're considered a qualified jurisdiction. They don't necessarily have presence. So then how do you, Division of Insurance, deal with them in the legal framework? Or is there a legal framework? Or is the jurisdiction then federal, and then you're trying to bring yourself under the Dodd-Frank Act? Because I'm just not clear on the legal lines of how you move between entities. Does that make sense? I mean, because there's a whole lot in Section 6. You could just did the bill in Section 6, and we'd all just been like, oh, okay.
This is Barbara Richardson for the record. No, and I appreciate that. It is very complicated, and this actually would set some of the legal parameters to make us then fall in line with the covered agreement, which falls on, I mentioned this before, falls under the Federal Insurance Office, under the Department of Treasury. So if there is pushback even under the qualified jurisdictions, which the qualified jurisdictions are required at this point to provide through not only through the National Association of Insurance Commissioners, but also through the Bank of International Settlements and the IAS, they're required to actually say that they will fall under the jurisdiction. So they have to agree to it in order to become a qualified jurisdiction. They actually have to submit their jurisdiction to follow the same requirements and alliances, and to provide the same rights that a U.S. citizen or a U.S. company would have in their jurisdiction. So this is to support that framework, or that legal framework for jurisdiction.
Thank you for that. And then, Madam Chair, I wanted to ask a question on 6.16, which is the solvent scheme of arrangement. And I guess what I wasn't clear on is there's a line on, it's line 28 and 29, but it says that means a foreign or alien statutory or regulatory compromise procedure subject to the requisite majority creditor approval. So in this context that you've given, who is the majority creditor who gives that approval? Who is that?
So this is Barbara Richardson for the record. That's going to be whatever the domiciliary country, domiciliary state. So for example, on the supervisory colleges, there is a determination that's made that where the bulk of the products are sold, or where the business is sold, that is considered the home domiciliary venue. So instead of a company hitting every United States, every state in the United States, if they have an issue, it's the same thing that we do in the United States. If there's an issue with a company, it has a domiciliary state, and every control, every sort of hit on the solvency issues, every oversight happens at the domiciliary level and then peels out to the other groups, so that it basically saves, again, we go back to saving time and money for the insurance carriers, thus saving time and money for the consumers, because the idea is that under the NAIC's accreditation process, we have to rely on the underpinnings, the underlying laws, the underlying controls that the financial solvency regulators in that state and are performing on the companies themselves. So this actually does the same thing, only on a national, or excuse me, a worldwide basis. So it falls though under the, you come to that agreement through these supervisory colleges to make that determination.
And then same section, because based on the context that you've given, like I immediately go into like a whole different span, because I was trying to understand how does notice work, right? Because immediately I get into like I think about like cases, like there was a case that I learned in law school. I think it was Burger King, but it was like this international thing about this tire stem, blah, blah. But the thing is, the notice provision that comes into play when you're dealing in international jurisdictions, I'm trying to understand how, what law does a person go to in order to then fall under this duly noticed class members, and what can they expect now that you've adopted this? Really, it's the U.S. bilateral agreement, but what can a person who's a part of this, I guess, expect to be the notice that they receive in regards to this when they're dealing with liabilities or any other issues that they have? Because Section 6.6 says a couple of things, right? So you're talking about duly noticed class members or creditors of a solvent debtor. And then it also throws in the reorganization or restructuring of debt. So that then brings us into that bankruptcy conversation, or what is that? I don't even know if, like, you have Chapter 11, you have Chapter 13. How does that work in the international framework when there is a person wants to reorganize their debt or restructure it, and they're in this bilateral agreement? And I'm just going to throw Bermuda back out there just for I was going to say for giggle's sake, but okay, I'll stop there.
So this is, yeah, that's right. Yeah, so this is Barbara Richardson for the record. So if Bermuda happens to be the domiciliary jurisdiction, they must chat with, and I say chat in a quietly sort of confidential way, they must get approval from the other regulators for certain types of restructuring. And the whole framework is based on making sure that that no consumers, which is the ultimate concern, are being harmed by the corporate structure or corporate changes that are put in place. And we currently happen to, I mean, there's a fight right now going on with a particular company who domiciled in a territory, who was allowing actions that the other states in the United States wouldn't allow. So the other states have stepped in and moved to remove that particular company from their domiciliary control. So.
Thanks, Madam Chair. I only had one other question. It wasn't even on that section. It was on Section 69. It was, because I don't know what this is. What is a prepaid limited health group? Because I really, yeah, what is that?
So Barbara Richards for the record, it's just small prepaid policies. It's just there are specific policies that people want to buy for an issue like cancer specifically, that they didn't think that they were getting enough coverage. There's not a lot of them on the market. There's not a lot of policies on the market anymore, especially since the ACA came out. But every once in a while, folks want to buy additional coverage on a health issue that they might have or that runs in their family. So they want to make sure it's out there. So.
Thank you, Madam Chair. That was it for me.
Thank you. Any other questions? For giggles or otherwise? Okay, seeing no questions from committee members, anyone in the room want to testify on Senate Bill 45? Any? Broadcast, let's go to the phones.
Thank you, Chair. If you would like to testify in support of AB 45, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 523, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Madam Chair. My name is Tom Clark. I'm here on behalf of the Nevada Association of Health Plans in support of AB 45, and I will give this one a ditto. Thank you.
Thank you, caller. Again, if you've recently just joined us, we are taking support on AB 45. To testify in support, please press star 9 now to take your place in the queue. Chair, you have no more callers in support at this time.
Let's go to opposition.
If you would like to testify in opposition of AB 45, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 020, please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 020, please press star 6 now to unmute yourself. Thank you. Please begin.
For the record, my name is Jim Wadham, speaking on behalf of the Nevada Self-Insured Group. We appear in opposition only because we have an amendment to discuss, and I apologize because I think this bill is very important and otherwise support it strongly. The commissioner has addressed in part the amendment. We only asked the opportunity to continue to discuss with her the issue are the self-insured groups. Essentially, this amendment comes in 3 parts. One is to clarify a ruling that was recently made dealing with standard industrial classifications. There's some language that makes that confusing, and we would like to see that removed. A question was asked about the audits. We think there is still some confusion about multiplicity of audits. In no way do we want to restrict the commissioner's power or authority to monitor the solvency, and the solvency standard remains unchanged. But we had an opportunity to discuss this with the commissioner's staff yesterday and just offered this amendment as a placeholder to continue those discussions. Appreciate her willingness to do that, and thanks the committee for the opportunity to at least put this proposal on the record. Thank you.
Thank you, caller. Chair, you have no more callers in opposition at this time.
Let's go to neutral.
If you would like to testify neutral on AB 45, please press star 9 now to take your place in the queue. Chair, you have no callers neutral at this time.
Okay, thank you. Commissioner, you have any closing comments?
This is Barbara Richardson for the records, and I do appreciate that we did have a chance to talk to Mr. Wadhams, the staff did yesterday. I would say though that one of the things that is trying to be removed is the term standard industrial classification coding system, and this is one of the situations where it is in English. It's not everything in the statute is in English, but it has been interpreted to mean something that it's not. And we have worked with the industry to explain to them that the standard industrial classification coding system is any classification system that's standardized under the statutes and falls under the advisory code. So by removing it, we're not actually gaining anything. All we would be potentially doing is somehow acknowledging that that meant something that it doesn't mean. So it's just unclear why we're trying to remove something that actually is in English for this. And I think I've already talked about the other particular solvency issues, which again, we would be happy to work with individual companies on as far as that goes. But we need to make sure that we actually have the opportunity to talk to them about where they fall and what their actual cash flow issues are and their tangible net worth. So and like I said, there are opportunities in the statute as currently written to have those discussions and to make allowances to get any SIG self-insured group member back on track without altering the statutes themselves. So I thank you for your time.
Thank you. And with that, we will close the hearing on Assembly Bill 45 and open the hearing on Assembly Bill 51, revises provisions governing the recovering fund administered by the State Contractors Board.
Good morning, Chair Spearman and members of the committee.
Now, can you speak a little bit louder, get closer to the mic? Yeah.
Certainly. Good morning, Chair Spearman and members of the committee. And I'd like to wish a very happy birthday to Senator Lang today. My name is Margie Green, and I am the Executive Officer of the Nevada State Contractors Board. Joining me today is our General Counsel, Tim Geswine, and our Director of Investigations, Paul Rosario. If it pleases the committee, I will provide introductory remarks concerning Assembly Bill 51, and then Mr. Geswine will speak specifically to the changes being sought within NRS 624. Mr. Rosario will also be available to address any questions you may have. AB 51 concerns the board's Residential Recovery Fund, which was established in 1999 with the assistance and leadership of Assemblywoman Barbara Buckley. Funded by Nevada licensed residential contractors, the Recovery Fund provides recourse for homeowners who are unable to have issues resolved by their contractor during construction. In many cases, the contractor may have abandoned the project, gone out of business prior to the complaint being filed, or the contractor's license was revoked. Since the first claim was awarded in 2001, over $13 million has been distributed to more than 1,500 Nevada homeowners, including seniors who invested their life savings into a project that was abandoned, young couples who often learned difficult lessons as they renovated their first home, and respected professionals who were taken advantage of. These stories help exemplify the board's public safety message and our ability to assist consumers at times they need it the most. As of March 31st, 2021, the Recovery Fund has a balance of $5.3 million and holds committee hearings at least once every 2 months to consider claims for awards. The board successfully increased the award amount during the 2019 legislative session from $35,000 to $40,000 for individual claims filed, and the aggregate value where multiple claims are filed against a single contractor from $400,000 to $750,000, or 20% of the Recovery Fund balance, whichever is less. This change now affords consumers greater financial protections when hiring a licensed contractor and allows the Recovery Fund Committee to award higher amounts when large claims are validated and approved. When consumers consider whether to hire a licensed contractor, the board wants to ensure the law regarding eligibility for the Recovery Fund is clearly stated. AB 51 does not change eligibility for the Recovery Fund. It simply clarifies eligibility requirements to assist the committee and inform the consumers when considering awards. Specifically, AB 51 seeks to clarify the definition of single-family residence while also affirming the Recovery Fund does not apply to owners of manufactured homes, as those residents are under the jurisdiction of the Manufactured Housing Division, who maintains its own licensing and enforcement authority. We are also increasing the penalty against contractors who fail to provide notice of the Residential Recovery Fund to residential consumers prior to work being performed. This provision has not been modified since the inception of the fund. The increased administrative penalty intends to promote greater compliance among Nevada contractors who are responsible for upholding the laws that aim to protect the health, safety, and welfare of the public. Failure of the contractor to provide such information could result in consumers not understanding their options for recourse with the contractor's board in the event something goes wrong with their project, which delays their ability to resolve health or safety concerns in a timely manner. Lastly, we want to clarify the Recovery Fund's ability to issue an award relative to a court-ordered judgment to ensure subrogation of rights stays with the claimant for any judgment amount that exceeds the board's $40,000 limit. At this time, I would like to turn it over to Mr. Guesswine to walk you through the bill.
Thank you and good morning. Chair Spearman and members of the committee. Again, my name is Tim Guesswine and I'm General Counsel for the Nevada State Contractors Board. The primary revision is in Section 1 of AB 51. This section defines single-family residence. The language makes it clear to all stakeholders who may be an eligible recovery fund claimant. This would be a new statute, but the definition matches the current practice of the Recovery Fund Committee, the group that hears and decides recovery fund claims. When considering this statute, the competing interests of the recovery fund's financial stability, the contractor's ability to pay assessments, and administrative efficiency were considered. With these changes, it becomes clear who is eligible for recovery from the recovery fund while still maintaining the recovery fund's financial health. Importantly, this definition does not redraw the public policy regarding eligibility that has always been at the core of the recovery fund. Instead, the single-family residence definition supports the long-standing public policy goal of providing assistance to Nevada homeowners. Another highlight is Section 4 of AB 51. This section offers a change to the recovery fund's subrogation right. Currently, if an award is made by the recovery fund, the injured person assigns all rights to the recovery fund. With the proposed change, the subrogation right is limited to the amount of the recovery fund award. This proposed limit on the subrogation right does no harm to injured homeowners. Instead, it will allow those Nevada homeowners who have suffered harms in excess of $40,000 to seek recovery fund awards and, after getting the award, to seek recovery for excess amounts by other methods. This change also leaves untouched any injunctive relief or other relief offered by a court. Finally, the limit of the subrogation right acts as a deterrent to those residential contractors that would use the recovery fund as a shield from their misconduct. The final substantive change is in Section 5 of the Act. The current statute requires residential contractors to give notice to homeowners regarding their recovery fund rights. Failure to do so can result in an administrative fine that is paid into the recovery fund. Section 5 of AB 51 revises the existing statute to increase the administrative fines from not more than $100 for a first offense to not more than $250. For a second or subsequent offense, the administrative fine increases from not more than $250 to not more than $500. These fine monies emphasize the importance of the recovery fund notice, and because the administrative fines are paid into the recovery fund, the fines help ensure its financial health. That concludes my prepared comments, but I'm happy to answer any questions.
Senator Lang?
Hi there. Thank you, Madam Chair. I just, so we're starting to have more and more tiny homes being built. And I'm just wondering where a tiny house would fit in here. Some are put on foundations, some are on wheels because they like to be mobile. But I see in the future that we may have tiny home communities, and I'm just wondering how they would fit in this statute.
Thank you, Tim Guesswine, responding to the question from the senator. A tiny home, at this time, I'm uncertain if tiny homes are governed by the Division of Manufactured Housing, in which case they would fall under its jurisdiction. But as this definition is written, if the tiny home is not on a foundation, it would not qualify for recovery fund awards. Again, recall, most of these tiny homes are built off-site and transported to its resting place, and as you mentioned, can be moved. That strikes me more as a manufactured home.
Senator Settlemeyer?
Thank you, Madam Chair. I appreciate my colleague's question because it kind of brings up the issue that I'm having with the bill is in section 1(3) by stating that the term does not include, because currently, if I'm correct, and please correct me if I'm wrong, under current law, manufactured homeowners, the damages for defective work, they pursue the 489 fund. And that's the recovery fund that they're limited to. That's where they're supposed to go. And it's based on who does the work. But AB 51 now will make the work of the manufactured home ineligible for the actual recovery fund. That means that their only remedy then would be the manufactured homeowners damaged by the defective work will be the 489 fund, regardless of whether the contractor did the work or not. And that seems problematic to me, because if the contractor does the work, even if it's on a manufactured home, why shouldn't that be the funding source? Why are we limiting based upon the type of home? Why don't we just do it based upon who does the work? If it's a contractor, you can go to to that fund. And if it was, the manufacturer, you go to that fund. That's where I'm getting confused.
Tim Gaswine from the Contractors Board, responding to the Senator's question. So you're correct. Work on a manufactured home does have the avenue of the 489 account, and that account is not administered by the Contractors Board. There was a bill change in Senate Bill 371 in 2019 that allowed some circumstances in which an NRS Chapter 624 licensee, a contractor, could work on a manufactured home. But those changes were made to Chapter 118B, and the title of that chapter is Landlord and Tenant Manufactured Home Parks. So what it allowed, Senate Bill 371, it allowed the owner of the manufactured home park to contract with licensed contractors to perform certain work. So by definition, those are landlords, and those are not those persons would be ineligible from recovery fund on two accounts. They would be ineligible under these standards of the manufactured home, and they would be ineligible because it is not an owner-occupied dwelling. The owner of the dwelling is renting the dwelling to a tenant. And the recovery funds has never reached down to protect landlords because of that's a protection of a business risk, that the landlord has the ability to enjoy other avenues and other resources to correct problems. The focus of the recovery fund has always been upon the single family home that is owned by a person and the harms that contractor causes to that homeowner.
I appreciate that. If I could follow up, Madam Chair. I'm still concerned because, again, what remedy exists against a bad contractor because they're not licensed under 489? So how do you get the appropriate person to pay for the damages? How do you go after a bad contractor in that situation if you're not going to be able to go after the Contractors Board resources and you're only limited to the 489? Because, again, the contractor isn't licensed under 489.
Tim Gaswine for the Contractors Board. So I'll remind everyone that the recovery fund is an important tool, but is not an exclusive remedy. So a person who is harmed by a Nevada contractor may seek other avenues for redress. Of course, civil litigation, there might be insurance or insurance claims are possible. There is the NRS 624270 bond that may offer coverage or protections in some circumstances. So this is not an exclusive remedy. There's an opportunity for a person who's been harmed to go to many different avenues and seek redress for the injuries caused. So while the recovery fund itself has been drawn and the policy limits have been established, they're not exclusive. There are other avenues for injured persons.
I appreciate that. Thank you. Thank you, Madam Chair. I'm just a little worried that those other resources usually are rather costly due to the fact that they're usually litigation, and that's my concern. Thank you.
Thank you. Additional questions? Vice Chair, and then Senator Pickard.
Thank you, Madam Chair. So I just had a question to try to follow up on what was just stated. So, and I just want to be clear around the exclusion. When you say, property owned, so how does this touch when the owner is deceased and then there's an estate that is now over the property, and there is an existing claim or a contractor issue that's going on? Because the way I read 1E, family is included if they, but I just want to understand like what happens if it's an estate and there's a contractor that did work and the owner is no longer living. What's the application of this language? Because is that being seen as a business or is that being seen as something else?
Tim Gesswein for the State Contractors Board. As I understand that scenario, a person who's hired a licensed contractor, that contractor has failed in some aspect, violates the chapter and caused an injury, and then the person passes, and the estate is now trying to get redress for that contractor's harm. I would suspect that the subsequent owners provisions would apply in that situation. Again, it's understood that sometimes a harm can be caused by a contractor, and that harm may not be found out right away, and this is a mechanism for that.
So the estate could bring an action against that contractor. I just need to hear that yes or no, because I kind of was still left with a question mark.
Tim Gesswein for the board. So ultimately, I believe yes, the estate, or after the probate is complete and there is an owner, then that owner would be able to make a claim to the recovery fund.
And then just a quick aside to that. So so probate's over and then there's a life estate given, do they have rights as well? The person who ends up with a life estate. So you have an estate and then you have a person who's given like the right to live in the property until their death after the original owner died. Do they then have a right?
Yes, what I would suspect in that scenario, which is an interesting one and is really not contemplated on the surface. So ordinarily, we're considering that the property is owned in fee simple and the traditional law school stuff about who owns the property. But you're suggesting a life estate, and under the life estate, that person would be able to make a claim, but of course there's still an owner, and that owner could also make the claim. So what I would suspect in that scenario is that the person holding the life estate, as well as the owner of the property, would probably making a joint application to the recovery fund for that harm caused by a contractor.
And because you guys are just changing existing, but what I don't know, and maybe you can just say this, I guess it's in, what's the time limit for you to then bring the action? I saw in section 4, but that's different. That's speaking to something else. So in the two scenarios that I talked about, when does the time run to bring the action against the contractor for the fund under the estate and life estate scenario?
Tim Gesswein for the Contractors Board. The recovery fund statute of limitations is established as 4 years from after the completion of the qualified services, and that's established in NRS 624480.
Thank you, Madam Chair.
Senator Pickett?
Thank you, Madam Chair. And thank you, Mr. Gesswein. I appreciate your presentation and your answers. I just want to get back to one of the statements you made with respect to the tiny house provisions and how they are not generally set on a foundation, which is true of manufactured homes of any kind. But sometimes they are. Sometimes we'll see these things set on a permanent foundation, and does that change the answer? Does that then somehow move those homes? And the same would apply to a modular home, for example. They're manufactured off-site, but they're manufactured then to typical housing standards, and then they are placed on a permanent foundation. Is that the trigger? That's not clear in this definition, but the way you used it made me think that, well, are we then going to exclude modular homes, which are manufactured to typical housing specifications and meet the current ICBO codes? Does this exclude those as well, even if they're set on a permanent foundation? Or does the manufacturer home or tiny home set on a permanent foundation then pull them back into 624?
Tim Gaswine for the Contractors Board responding to the Senator. Senator, the tiny home and manufactured home concern really rolls around, of course, the division and its role as the overseer, the government body that investigates those aspects, as well as the Contractors Board lack of expertise in those areas and how they fit together. So at this time, while we understand that sometimes some structures are essentially prefabricated and then affixed to real property, at this time, because we're unaware of what would happen to that would be an expansion of the recovery fund, and we're unaware of what would happen to its funding, its ability to pay for claims, its ultimate financial strength, and of course this overlap with the division and how we've always understood that the site improvements, say for instance, a manufactured home is affixed on real property and a person builds a standalone detached garage. Everything up to the skin of the manufactured home would be an improvement that the Contractors Board would have jurisdiction over, and should there be faulty workmanship or an abandonment or other thing that would trigger a claim, there could be award from the recovery fund. But once inside the skin, once the skin is pierced, then we've always accepted that is within the division's jurisdiction.
All right, and so going back then to a modular home, which even national home builders have engaged in constructing, those would fall under the board's purview because those are built by contractors who then affix them to the permanent structure. So even though technically they're manufactured off-site, they're manufactured to normal building standard, as you would a stick frame residence that's built ground up on the site. Would those would still be eligible for recovery under the fund, correct?
Tim Gaswine for the board. So what I understand the question to be is, say a licensed contractor is assembling in a fabrication shop, say panels, wood frame panels with a sheathing and those things that are then transported to a construction site and erected at site, which is a very common practice now as contractors work to achieve efficiencies and higher production standards. That would remain still a stick-built house under the recovery fund, eligible for recovery fund, because it's being built at site. While portions are being transported, that would fall under recovery fund. Again, the distinction is who licensed or controlled the original construction. If it was the division, then it's a manufactured home and not eligible for recovery fund.
Okay, and I guess that right there is what I was looking for, because in my case, I know that one of my employers, actually two of my employers, that were national home builders, they're licensed, they build stick-built projects, not in Nevada, but in other states. They attempted, they tried it out. They built not just panelized construction, but entire modules that they would manufacture off-site. They would truck them in. They would place them as a completed structure. They would, or component of the structure, they would set that on the foundation, and then, but the majority of the home itself, from the plate to crown of the roof, was built off-site. And so, but because these were home builders, they were licensed under 624, they manufactured that home off-site, then brought it on-site, set it on the foundation. It sounds like they are covered based on what you just said. So I just wanted to make sure that that distinction was clear, because I don't want anyone to interpret modular construction to be the same. You know, modular construction that was built by a home builder that's licensed under 624, that somehow they are not eligible for recovery under the fund. So unless I've misstated what I think I understood you to say, I'm satisfied.
Tim Guesswine for the board. You understand we understand each other.
Additional questions? So I guess I have one. Is an amendment possible to make sure that there's clarity here? That's a question to the sponsors, not the committee.
We would be happy to look at an amendment. Margie Green for the record. We'd be happy to look at any amendment that is proposed and consider it with board legal counsel.
Okay, and I'm going to ask if you all will work with our counsel, Mr. King, on that. I think the concerns are not just valid, but I could see down the road where that could be a problem, and would hate for something that is technical or semantic that would preclude someone from getting their just due. So, Mr. Keene, if you'll work with them as well, I'd appreciate that. Any additional questions? Okay. Thank you. So if there are no more additional questions from the committee broadcast, let's go to the phones.
Thank you, Chair. If you would like to testify in support of AB 51, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 184. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair Spearman and committee members. My name is Matt Walker, and I'm pleased to be providing comments this morning in support of Assembly Bill 51 on behalf of the Southern Nevada Home Builders Association. The Residential Recovery Fund is the home building industry's commitment to home buyers. It makes homeowners whole within a matter of weeks when a residential contractor is unwilling or unable to rectify damage to a home. Southern Nevada Home Builders Association see themselves as supporters and custodians of these funds, and for that reason, last session we supported Assembly Bill 26, which increased the amount of that the recovery fund could pay out to individual homeowners, and AB 440, which required a single-page disclosure describing the rights to pursue the recovery fund at sale. And so this session, we fully support AB 51 in order to provide greater clarity to the public regarding fund coverage and protect the fund to ensure adequate resources are available for homeowners. By defining eligible homes, the bill ensures that owner-occupants of condos, townhomes, and duplexes have access to the fund. As these types of homes are a fast-growing segment of some of our most affordable new homes, it is critical that these homeowners are aware of this resource and have access to the fund and can be made whole within a matter of weeks by completing a simple form. We thank the Contractors Board for bringing this issue forward and urge the committee's support. And because there was some conversation, I just want to be clear that our general rule of thumb on recovery is that it depends on who issues the permit. So a permit issued by a building department, that homeowner would pursue investigation and recovery under the State Contractors Board. If the Manufactured Housing Division issues the permit, then the Manufactured Housing Division will be responsible for investigation of workmanship issues and access to its fund that's paid for by park owner assessment fees. So thank you again for your time, and please support AB 51. Thank you.
Thank you, caller.
Hold on, broadcast. Senator Pickard has a question. Is the caller still there?
No, he dropped off right away. Sorry, Chair.
Okay.
Madam Chair, I'll take it up with Mr. Walker offline, but I think he makes an important distinction because that has been the historical approach. Is we look at who pulled the permit, and in the scenario that I'm thinking of, it's the builder or the contractor that's going to be setting, whether it's a manufactured home, the tiny home, or a modular home. They've got to pull a permit in order to build the foundation and do the underground. And if they're pulling if they're a contractor under 624 pulling the permit, then they will rope in the others. And my concern is that this bill appears to be narrowing the scope of applicants for the recovery fund. And I'm not sure I can support that if that's the case. So that's why I'm trying to get down to, where are we drawing this line and how does it differ from what we had before? Anyway, I'll take that up with Mr. Walker. Thank you.
Okay, thank you. Broadcast, please continue.
Thank you, Chair. Caller with the last three digits of 175. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair Spearman and members of the committee. Lindsay Knox with McDonough Carano on behalf of the Builders Association of Northern Nevada and the Nevada Home Builders Association here in support of AB 51. The home building industry takes every opportunity possible to highlight.
Hold on just a minute. Can you, hello. Hold on just a minute. We need you to state your name and spell it slowly and then begin.
I apologize, Chair Spearman. Lindsay Knox, Lindsay, Knox, KNOX, with McDonough Carano on behalf of the Builders Association of Northern Nevada and the Nevada Home Builders Association in support of AB 51. The home building industry takes every opportunity possible to highlight the importance of the Recovery Fund as an effective alternative to litigation. The Recovery Fund provides a tested and efficient remedy for consumers victimized by defective work. Homeowner claims against the Recovery Fund are adjudicated within 6 months. By contrast, most lawsuits take years to be resolved. We support AB 51 because it ensures the ongoing viability of the Recovery Fund, protects homeowners, and ensures that contractors are held accountable for substandard work. We'd like to thank the Contractors Board for working with the home building industry, not only on AB 51, but also to address builder concerns on other board bills to this session. Thank you.
Thank you, caller. Chair, you have no more callers in support at this time.
Okay, let's move to opposition.
If you would like to testify in opposition of AB 51, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Okay, we have someone in the room in opposition, and I didn't call for support. Anybody in the room for support for AB 51? For support? Okay. We're going to hear from someone here in the room for support, and that's my fault. I didn't call for that before we went to the phones.
Thank you, Chair. My name is Alexis Medorex with the Nevada Chapter Associated General Contractors.
Can you speak up a little louder, please?
I'm sorry. Can I pull this down? Is that legal? Can I? Alexis Medorex with the Nevada Chapter Associated General Contractors. We are here in support of AB 51 as presented. We believe this is building on a successful program by clarifying who is eligible to receive these funds. We believe it is good public policy and will continue to build confidence in the construction industry. Thank you.
Anyone else in the room for support? In opposition? Broadcast, we have anyone on the phones, on the lines?
Chair, your public line is open and working, and you have no callers at this time.
Any for neutral?
Chair, your public line is still open and working, and you have no callers at this time.
Okay, thank you. Committee members, additional questions or comments? No? Okay, so Ms. Green, do you have any closing statements?
Yes, Margie Green for the record. Thank you, Chair Spearman and members of the committee for the opportunity to present AB 51 today. The Residential Recovery Fund has been a valuable resource for Nevada homeowners for the past 22 years. The Contractors Board has been identifying opportunities to improve and clarify the Recovery Fund program in recent years as new trends are noticed, and we feel the changes proposed before you today further these efforts. We hope that we have answered your questions concerning the intent of AB 51 and are more than happy to provide additional information of interest to the committee as needed. And again, thank you.
Thank you. And with that, we will close the hearing on Assembly Bill 51. Take a real quick break, broadcast to get set up and we'll go into public comment. See if we have anyone on the lines for public comment.
Chair, your public line is open and working, and you have no callers at this time.
We'll wait just a little bit longer.
Thank you, Chair.
Still no one?
You have no callers at this time.
Okay. All right, thank you. And so we'll close out public comment. Are there any comments or questions from committee members? Here we go. Okay. So this will conclude our meeting for today, and we will meet again on Monday, the 3rd of May at 8:00 a.m. Thank you so much, and you all have a happy weekend. We're adjourned.